Welcome to the White Bay Health Service. My name is Bee, and today I'm going to give you a quick overview of the medical litigation process in Queensland. All of us are familiar with our duties as health professionals, and we do our best to take care of our patients. However, over 500,000 adverse events occur in Australian hospitals each year. Our patients often come to us already seriously ill. It is not always possible to prevent adverse outcomes. It does not mean that there has been any negligence. Nevertheless, the unhappy patient is able to sue or complain. If they want compensation, they would have to lodge a legal claim. The whole process can take years and negatively impacts on the health professional who risk becoming a second victim of the adverse event. Seeing someone get sued also affects general morale among colleagues, resulting in hedging and avoidance behavior, which is bad for patient care. So why do patients sue? Primarily, they feel that their expectations have not been met. They are angry, feel ignored, and that someone should be held accountable for what has happened to them, particularly when they have suffered permanent harm. This situation is compounded by insensitive handling of their complaints and poor communication. So who can sue? The patient or someone on his behalf? If the patient dies, his right of action survives to benefit his estate. Who can be sued? Any practitioner or health service. The law allows patients to include multiple defendants if they are uncertain who is to blame. In order to prove negligence, the patient must show that he was owed a duty of care. There's been a breach of that duty which has caused an injury. There's a separate duty to warn of any material risk in giving information and taking consent. The claim is brought in state courts, so the law may be different in other parts of Australia. What can the patient sue for? The patient can sue for medical expenses, loss of income, home care costs, pain and suffering. However, time is of the essence. While the patient has 3 years within which to launch a suit, in Queensland there is requirement to give notice within 9 months of the injury. Litigation contains many long and complicated steps, but there must be a compulsory conference during which a mandatory offer to settle must be made. If you get sued, you should seek advice from the legal officer and your line manager. You should make a written account of everything you can remember about the case while it is fresh in your mind. The 3 G's of good patient care can help prevent you from getting sued. Firstly, good communication. Here, active listening skills and empathy are key. Clear and simple language should be used to explain the risk and benefits of any treatment, and especially when explaining any adverse events. Secondly, good practices in keeping up to date. Follow-up care and handing over care will help to prevent errors and unsatisfactory outcomes. Finally, good record keeping is essential as the court treats contemporaneous records as facts. In conclusion, if you are facing a legal claim, help is available. Please read the pamphlet for more detail. To avoid one, remember the 3 G's of good patient care: good communication skills, good practices, and good records. Thank you for listening.